My God, I hate drugs.
It's been 10 days since the 8 justices decided to oust you. How have you been since? Has there been any change?
The point of view that I shared with you remains valid because you have seen 14 senators give their sense that they should be the ones to decide on whether the Chief Justice should be removed from office or not, and not the Supreme Court. That's a major development, Pinky, and I think everyone should pay attention to the fact that the exclusive body vested by the Constitution with the power to remove impeachable officers is exerting its right. It's not something that can just be easily set aside.
14 of them, I want to talk about that a little later on because we also need to talk about the House of Representatives. But just personally, how's the challenge been since 10 days ago, since that decision, ma'am?
The challenge now is basically to help people understand why it is important to preserve the checks and balances and why co-warranto should not be used to erode our constitutional gains. Ang dami nang nakuha natin bilang isang bansa, Pinky. We have been already hailed as a champion of democracy. Naging model na tayo sa Asia. So many people launch their own democracy movements patterned after ours. So, ang problema na lang, kailangan nating cascade down sa taong bayan. So, I have been listening very carefully, and people have been saying that your issue, your cause resonates with us. So, obviously, it's not about me anymore. Parang lumiliit na nga yung aking role eh. Parang taong bayan ang nagte-take over ng cause. So, I'm happy to share this fight with so many others. It's not a personal one. It's obviously something that is about principles and the basic values of us as a people. Ano ba talaga ang ating pinahahalagahan? Yung respeto sa bawat isa, na hindi mag-concentrate ang power sa iisang tao lamang o sa iisang sangay. At kaya pa bang takbuhan, tumakbo sa mga judges kung sila ay natatakot dahil sa co-warranto? Kasi ang co-warranto ngayon, hindi na pwede yung 1-year prescription period.
Rule 66.
Correct. Wala nang Rule 66 effectively na mapagsasabi. Yan ang sinabi nga nagpakamatay na daw ang hudikatura. So, sabi yan ni Justice Kagiwa, no? At nanganak ng legal abomination ang Supreme Court. So, kung gayon pala, ang kailangan natin pag-isipan ano bang ibig sabihin nito sa maliliit na tao? Ang presyo ng bigas, ang presyo ng petrolyo, ang taas ng bilihin, ang mga kahirapan sa buhay. Paano na yung mga negosyong maliliit na natatanggal na lang bigla? Tatakbo sila sa huwes, pero yung huwes nanganganib. Pagkalaban ng mga maliliit mabibigating tao, isang connection lang sa Solicitor General at sa Presidente o sa political allies man lang nila. Nasaan na ngayon ang karapatan ng tao?
I want to jump to that. I wanted to ask you, I think it was Senator Franklin Drilon who said that the Solicitor General is the most powerful person in the bureaucracy. If I'm not mistaken, that came from him. Do you agree?
Yeah. He has been turned into the most powerful person now, next to the President. Even more powerful than the Senate combined. All 24 senators cannot do what Soljan Kalida can do now.
Does this mean, CJ, that every trial court judge, any member of the judiciary, the CA, the Supreme Court, can be exposed to a co-warranto petition?
Yes, that's the clear message to everyone. You weaponize a rule that is not often used in the Supreme Court and in the judiciary, and then you destroy everything in the Constitution that prevents such an abuse of power. One obscure rule, hindi man masyadong obscure, pero obscure enough to say that there are not many, very, very few co-warranto cases. All of them saying that basically it's just exactly, the rule has always been uniform. Not more than 1 year.
Okay, I wanna talk about that just for those who may not be very aware of that. That's Rule 66 in the co-warranto. It says that basically there's a, please correct me if I'm wrong, ma'am, a 1-year prescriptive period by which a co-warranto can be filed. There were two experts, I would say, I spoke to. One is the former Chief Justice Hilario Davide, and the other one is Justice Nachura, both having opposing views. One said it's a one-year prescriptive period, which means 2012, the time you were appointed. Dapat 1 year from then, which is 2013. But Justice Nachura was saying that it's 1 year from the time of discovery.
Medyo mahirap paniwalaan yung ganong paninindigan kasi ibig sabihin mo, palitan mo yung Solicitor General tomorrow, bago ang Solicitor General kasi hindi natin alam kung nasaan, may mga issues siya ngayon, no? Malay mo, tomorrow hindi na siya ang Solicitor General, bago na. E di yung 1 year period na yan, magra-run for all the 1 million public officials, officers in the country kasi hindi lang yan applicable sa impeachable officials sa lahat. So for the 1 million, magbibilang ulit sila. Ano ang malalaman niya within 1 year? Yun, pwede siyang mag-file. Kahit ni retirement na yung
So
tao.
yung time element is forever? Is that what you're saying?
It's forever. It's basically gone.
So, malabo ho talaga sa inyo yung upon discovery, as Justice
Wala
Nachura
talagang
was saying.
reason. Wala talagang reason.
Ma'am, however, there is, when you talk about, well, obviously members of the administration, they would say that yung operative word kasi in the Constitution is may be impeached. In other words, there are other options to go to, such as a co-warrant, o hindi naman shall be. Meron daw difference ang shall be at may be.
Magandang discussion yan sa dissent, no? Kasi yung maybe, when taken into the context, only talks about the fact that discipline does not only talk about impeachment. Pwede mga disciplinary measures less than removal. So maraming pwedeng gawing pagdidisiplina ng isang impeachable official. Pero hindi mo ibig sabihin na linagay mo lang ang maybe, bubuksan mo na lahat at ita-transfer mo ang power from the Senate to the judiciary at the initiative of the Solicitor General. That was never the intention. Clear yun sa deliberations ng Constitutional Committee.
You have 15 days to file your motion for reconsideration. I know, ma'am, that it's difficult to discuss this being sub judice, but when will you file the MR?
Well, it will be on or before May 30.
Are there new arguments?
I'm sure my lawyers would want to be the first to show the new arguments. So let them finish it first, and then we can announce the new arguments.
How much of a participation do you have, being the accused and the Chief Justice herself?
Just enough so that I do not unduly intrude into the professional work of the lawyers. I have to show them utmost respect. But I also want to make sure that my personal convictions are fully reflected. If they need to be quite strongly articulated, but respectfully, they will be. They will find their way in some of the words there.
I want to get this clear, ma'am. Some are saying that if there is a change of heart and it becomes 7-7, that still this does not keep you a CJ. It doesn't put you back in position. What some are saying, that's why gusto ko pong linawin, do you need 2 votes to overturn the decision, or do you need just 1 vote to overturn the decision?
I will leave it to the rest of my colleagues to rule on that or to decide that. I will not preempt their action on the matter.
So is that a question mark?
Well, that means that basically I know that there may be a debate on that, so I will not join that debate.
All right. 8 justices said you were not qualified. Status co-warranto is justified because you were not qualified to begin with. Okay, that's going into the merits of the the motion for reconsideration that you will file. However, you asked 6 of them to inhibit. And when you spoke right after the decision, you said it was a victory because out of the 8, only 2 actually said that you should be ousted.
Yes.
Let's talk about that.
Yes, that's a moral victory because obviously basic rules of fairness, just even plain common sense, requires that your accuser cannot be your judge. And 5 of them testified against me. So clearly under the rules on compulsory inhibition, they should not have participated. And 1 thereafter said that I am unfit because I profess too much belief in God. So he has already expressed a bias, and so I then said that he should also inhibit. If those who had shown bias and prejudgment on my fitness to sit, and some had even shown personal hurt, expressed personal hurt at my assumption of office, then they should really inhibit. If they had inhibited, it would have been a clear and resounding victory. It would have only been two who would have said that I should step down.